Welcome, welcome, welcome. A Convict's Thoughts, ARHayes, bright and early, Tuesday morning. We made it through Monday, everybody. We made it through Monday. Now we're up bright and early on Tuesday morning, still revving to go. First things first, just real quick before I get into the meat and potatoes. I love when other content creators say that. I want to do a question and answers video again tomorrow for all of you. So anybody that has a question for me based on maybe an opinion you would like me to give, or maybe some details of what I've experienced on a certain type of thing, whether it be through the court process, the arrest process, all the way through trial and anything of that nature, you're more than welcome to ask me questions. Please put them in the comment section. I'll actually take note of them. And then I will do a video, and I will also, I'm going to be doing a live on Thursday, probably about 4 p.m. West Coast time, 7 p.m. East Coast time, to where I will be doing a live on the Idaho 4 case, and I can also answer some questions regarding that as well. So just a quick throw out on that for you. Later today, probably more in the afternoon, evening time, I'm going to be switching my videos for the day from the Idaho 4 case. I'm going to be speaking on the Delphi case with Richard Allen and my thought processes on that, from what I'm learning and quickly diving into on that case. Is I hadn't paid a lot of attention, but now I'm kind of diving into it. So later today we'll be focused with a couple of videos on the Delphi murder case, and I will also hopefully be joining Dago in his actual group today on a live discussing that as well. So please join us, and I'll put the link to his channel in the description of this video. So if you have not joined or subscribed to his channel, please do. Absolutely amazing man, great content, great community, great channel altogether. I highly respect it, and I truly feel blessed to be a part of it. So I want to kind of go real quick. I'm changing course a little bit in this video. We're going to get to an actual personal experience, and I'm going to discuss what it's like when you dispute a grand jury, as I've actually done it in my life in regards to my criminal syndicate case. So I'm going to give you a little bit of experience of what I went through and what the Idaho 4 dispute is most likely going to look like, is they've disputed the grand jury indictment within the case, and they're also requesting a dismissal of charges. So I have been through that, and I'm going to explain one of my experiences to you now. I was being charged with a felony 2 criminal syndicate charge, which carries a life sentence with no parole. It's pretty much considered to be organized crime, in a magnitude that it's more than one person. It's almost like a gang type charge where they're trying to get more than one person convicted. Criminal syndicate can cover anything from financial crimes, violent crimes, tampering with evidence, and also witnesses in cases. It covers a wide range of charges. So they lump it all into one big charge. It's a felony 2, so it's right below felony 1s, which is capital. So it was a big charge for me, and it was going to be a true battle, because they had a lot of, it seemed like, information and evidence against me on a pretty big scale. So we disputed the grand jury indictment in my case because we learned that 2 of the witnesses that came before that grand jury with testimony actually lied. One of them lied upon where they were during the time of said crime, and their witness statement put them at one place where it was actually found that they were somewhere else. So they lied to the grand jury. The second witness that testified, the reason that we went after that witness's testimony is because they were pretty much stating that another witness's testimony was correct when this actual said witness would have no idea. They didn't even know that witness. So obviously issues. So we had to dispute it, even though a lot of the stuff within the grand jury was pretty strong and it was good evidence. Those two situations that we put into dispute for actually overturned the indictment. It got the indictment dismissed. So now, I at that very point, I was considered a free man because there was no indictment against me. Once that was dismissed, the prosecution immediately rose and filed more charges directly through the court, and I was rearrested, recuffed, and taken from the courtroom back to the jail and put through the booking process all over again. It was a brand new arrest. So I did not even have a chance to turn around and wave at my family or do anything in the courtroom because I was already put under arrest and immediately escorted out as a brand new, booked, on their way to booking inmate. So I want to interject when people get a little bit excited that feel as though this defendant in the Idaho 4 case, Koberger, has the possibility of getting the grand jury indictment dismissed. That's great. It's a good step forward because it's going to allot him the opportunity to restart from the very beginning. What I mean by that is they're going to rearrest him, and they'll do it before he even leaves the courtroom. They'll go back through the booking process, and at that point, he gets his rights to a speedy trial back. He also gets his right that when it comes before the judge, he's going to make sure that he's indicted again. And I have a gut feeling in this case that they're going to put into effect that it will probably have to go through a preliminary hearing. It's just a guess. It's an opinion. That's what they did to me. They forced it to go back through a preliminary hearing, which was actually beneficial because we were able to put on a case and actually dispute the witness testimony and do a lot of things within the preliminary hearing, giving me a better shot of actually beating the indictment, which I didn't do. I mean, I got indicted, but it will allow for them to get up there and interview the witnesses that they are seeking to be able to do. If you all remember, they had a scheduled meeting with Bethany Funk prior to the grand jury indictment, and they feel as though they really want to discuss things with her, and I believe that grand jury indictment saved her from having to do that. Well, now, if this all goes appropriately, I believe they're going to be able to get her to have to come to the preliminary hearing if that's what the judge decides needs to happen to be able to go through the indictment process again. I personally was benefited in my dispute and the winning of my grand jury indictment dispute because I got my right to the speedy trial back, which put pressure back onto the prosecution, and that was our main goal. We wanted pressure on them so that they could not continue to investigate and get more evidence through the process. Right now, many don't understand that while this defendant is sitting in jail and we're going through the motions and everything going on, the investigation is still going on behind the whole darkness of the secrecy of, the Idaho 4 case. They're still digging for evidence, and because there's no speedy trial requisite here, that's given them all the time that they need to find more evidence. So it actually hurts the defense even though many would claim that, it hurts the prosecution and the defense, and it really doesn't hurt the prosecution, because they're okay with the extra time, because now they can dig and dig and dig. They can look for more witnesses. They can look for more evidence, where the defense has to wait for that evidence to be found, or those witnesses to be found, so that they can build their defense for those. Their client is still sitting in jail, so it's not really all that much of a benefit for the defense. They've already pretty much figured out what experts they're going to need. They already know their game plan in, fighting this case. They've already seen a lot of the discoverable evidence, so they know their game plan. This is the benefit for the prosecution. A dismissal in the case, which I've also had, is a different realm than what disputing and winning the indictment against, the grand jury would be, because the dismissal now, again, is going to restart everything, and they're going to have to go through the whole indictment. However, there are certain times when a dismissal happens, let's say for the basis of lack of evidence or misconduct or something of that nature, that a judge will put an onus on it for them to be able to rearrest, for them to be able to move back forward against said defendant. More evidence would have to be presented, meaning a new probable cause affidavit for arrest would have to be written, presented with newfound evidence, stronger evidence, before an arrest warrant would be signed off on and allowed. So when people say, well, if a dismissal happens and he would never walk out of the courtroom, blah, 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 in many cases that's very true. Not all cases. Not all cases. I've walked out of the courtroom for lack of evidence in my dismissal, and they did not rearrest me right away. It was weeks after the fact that they were able to obtain a new arrest warrant. And once, they couldn't even get the arrest warrant because they didn't establish any new evidence than they had previously. So when we see a lot of these warrants that are sealed, obviously, and a couple of them just became unsealed, we discussed those not long ago in regards to, the YouTube and a few of the new Amazon requests that wanted to see into his shopping carts and his history of, what he was looking for on Amazon. That's looking for more evidence. So if they are finding new evidence and a dismissal does happen, they would be able to present that within the court setting and probably write a new PCA rather quickly and get an arrest warrant and immediately detain the defendant. If they haven't found what they were looking for and they have to rely on what they previously put in, and that motion to compel on the IGG results will go a long way within that as well, meaning that if for some reason it got dismissed and they didn't have new evidence, and then all of a sudden the dispute over that is said and done, it's going to take them time, if they have to rebuild the family tree and do the work again, to be able to present that for an arrest warrant, which I'm sure behind closed doors they're already doing that, ladies and gentlemen. I'm sure that they're already preparing for that situation. They don't want to have to turn it over, but I have a gut feeling it's being prepared, just as an in case. But you just never know, and I'm not an attorney. I'm not a lawyer. I've just been through it, and I've been through both senses where they rearrested me immediately, and I've also been through the sense where I actually got to put my own clothes back on and walk away, and I stayed out until they were able to get another arrest warrant. So it could go either way. This case isn't going away. I'll be one of the first ones to admit this defendant's he's gonna be on trial for a while. Whether a dismissal actually comes through, I have a gut feeling they probably have found what they consider to be more evidence, and they'll present that in the PCA, and we'll find out rather quickly, how strong their evidence is when they have to refile the charges. So, in my opinion, I think that might be the best bet to clear a lot of this mess up in the Idaho 4, is wipe that slate clean. I sure hope this judge that's listening to it sees all the damage and all the craziness that's going on within this case, and he can make the determination that, hey, maybe we need to hit the reset button here, and let's get back reorganized, let's restart this. And that's not what everybody wants to hear. I mean, none of us want to hear that they got to restart everything, especially the victims' families. But if we can get it back on the right page to where things can become more visual and handled a little more appropriately, to where there's not questions in regards to whether the grand jury was correctly convened or handled or any of that nature, and maybe, show that there's not a lack of evidence. I know it will still be under seal, and it will still be probably under a gag order. The gag order is not going to go anywhere. That's going to be there. But I think it'll prove that if a PCA is rewritten and an arrest warrant's issued, and the defendant quickly gets back in, and it's heading towards a speedy trial, that this has probably got some evidence that we don't know about that's stronger and gonna have a lot of proof behind it. But you never know, ladies and gentlemen. I've seen it where dismissals happen and they never refile charges because they realize they just don't have the evidence, and 5-6 years later they're still investigating the case. So I just wanted to get on and give you a little bit of an idea. When you dispute a grand jury and you try to get a dismissal within a case, even when you are successful as a defendant, there's no expectation that you're walking out of the courtroom and going home that day. Very possible you're heading right back to the jail and going through the booking process again, and you just get a reset in the timer. You get a reset of your rights for a speedy trial, and maybe that's what the defense really is shooting for here. Maybe that's what they want. They want to reset it, and they want the rights restored, and obviously the discoverable evidence to be turned over in a timely manner, and let's move forward. But that's my video for now. A little bit of a description of a dismissal and a grand jury indictment, dismissal attempt, and we'll see what happens. October 26th, Idaho 4, big hearing. It's the dismissal hearing, and we'll see what's going on. So, big shout out to Dago and his show. I look forward to engaging with him as much as I possibly can. And thank you to all of you, the subscribers, and anybody watching my show. I appreciate each and every single one of you. Live coming on Thursday. Hope to see you there.